So good, so good, so good.
Everything you want for summer is at Nordstrom Rack stores now, and up to 60% off. Stock up and save on the brands you love like Vince, Sam Edelman, Frame, and Free People. Join the Nordy Club to unlock exclusive discounts, shop new arrivals first, and more. Plus, buy online and pick up at your favorite Rack store for free. Great brands, great prices. That's why you Rack.
What they did to your family, you're lucky to make it out alive.
Streaming on Peacock.
These men are going to come after me. Taking them out is my only chance.
Put a bullet in her head.
From the co-creator of Ozark.
Looks like a family was running drugs.
Execution-style killing, it's rare for the Keys. Any leads on who they might have been running for?
The cartel killed my family. I'm gonna kill them. All of them.
MIA. Streaming now. Only on Peacock.
Welcome back, True Crime Army. I am your host, Margot, and this is Military Murder, a show where I discuss true crimes committed by military members and veterans. And I do this with one goal in mind, to remind you to remain vigilant always. We are nearing the end of our mini-series on Jeffrey MacDonald, and it has been quite the endeavor. If you haven't listened to parts 1 through 3 yet, pause here, listen there first, then meet me back here for part 4. Today, I am walking you through the 1979 federal trial that took place in North Carolina. I'm also going to be discussing some of the appellate aftermath. I do have one more part for you next week, and that's going to be breaking down the wilderness of error viewpoint. So you won't want to miss that. Make sure that you follow up. Join me today as we discuss the case of United States versus Jeffrey MacDonald. Now, let's dig in.
Military murder is an independent project and is not endorsed by the Department of Defense or any military component. The views expressed are those of the host. The content of this podcast is not meant to be legal or medical advice. Warning, this episode contains graphic details of murder and is not suitable for young listeners. Listener discretion is advised.
June 8th, 1979. The Birmingham Evening Mail has an article about a police officers association in California that is holding a fundraiser for a local doctor. The doctor is accused of murdering his pregnant wife and 2 daughters. The Long Beach Police Officer Association paid to print 5,000 invitations to a benefit dinner for the man, and his name is Jeffrey MacDonald. Dr. MacDonald will be on trial soon, but the president of the Long Beach Police Association, Mike Tracy, said they ran their own check on the case file, and the facts do not support the charges. June 20th, 1979. A few weeks before the trial of the decade begins, Joan McGinnis writes an article for the Miami Herald that stops readers in their tracks. He paints a picture of a man who didn't just survive a tragedy, he thrived in its wake. At 35 years old, Jeffrey MacDonald is a UCLA faculty member, a published author, and a leader in emergency medicine. He's living a sun-drenched California dream. He lives in a $225,000 waterfront condo in Huntington Beach. He has a 40-foot yacht parked out back and a Maserati-powered Citroen. He's handsome, debonair, and he's dating a flight attendant. To his staff, he's a hero. But in just a few days, this golden boy has to trade the Pacific Coast for a courtroom in Raleigh, North Carolina, to answer for the 1970 slaughter of his pregnant wife and 2 daughters. Last week, I told you that I didn't know what the big deal was about Jeffrey MacDonald being a doctor, because after all, he had only been a real doctor for a year or 2 when the murders took place. But the thing I hadn't realized is that in the 9 years after Jeffrey left the military, he continued living his best life, as you just heard from that article, And in fact, as I browsed newspaper articles from 1979 leading up to his trial, Jeffrey MacDonald looked like a movie star almost. He wore 3-piece pinstripe suits, fancy sunglasses, and he had this feathered hair that kind of reminded me of the Charlie's Angels from back in the day. I mean, this man that walked into the courtroom every single day, it made sense why everyone was following the case because he didn't look like a triple murderer. So let's get into the trial. In July of 1979, nearly a decade after the murders inside 544 Castle Drive, the case against Jeffrey MacDonald finally reached a courtroom that mattered in a very different way. This was no longer an Article 32 hearing where the outcome could be brushed aside as a recommendation. This was a no-kidding federal criminal trial held in Raleigh, North Carolina, in front of a jury that would decide once and for all whether Jeffrey MacDonald was a grieving husband who survived a brutal home invasion or the man who murdered his own family. Opening statements began on July 19, 1979, before Judge Franklin Dupree Jr. And from the very first moments, it was clear that this case would not hinge on a single piece of evidence. There was no confession, no eyewitness who saw MacDonald commit the crime. Instead, the government would present what prosecutors believed was a tightly woven, circumstantial case, one built on physical evidence, forensic interpretation, and the argument that MacDonald's story simply did not match the reality of the evidence inside that home. The prosecution's opening statement, delivered by Assistant U.S. Attorney James Blackburn, laid out their theory in straightforward terms. They told the jury that this case was not about mysterious intruders or drug-crazed hippies. It was about one man inside his own home who committed a brutal series of murders and then attempted to stage the scene to look like something else. Blackburn explained that the evidence would show that the murders were not random, they weren't chaotic, and they weren't the work of multiple attackers. But rather, the evidence would show it was a sequence of controlled acts carried out within the house itself. The defense responded with a very different framing for the jury. Wade Smith, speaking for the defense, told jurors that they would hear about sloppy police work, contaminated evidence, and investigative tunnel vision. He argued that the government's case depended on assumptions, on interpretations layered over a compromised crime scene, and that the jury should remain open to the possibility that MacDonald's account, as unusual as it sounded, was still consistent with the presence of intruders. From that moment forward, the trial became a battle between two competing narratives, one grounded in forensic reconstruction and the other rooted in doubt about how that reconstruction had been built. The prosecution began by taking the jury back to the early morning hours of February 17, 1970. Through the testimony of responding military police officers, including Kenneth Micah and Richard Tavere, jurors were walked into the house as it had been found that night. They heard about the condition of the rooms, the location of the bodies, and the presence of Jeffrey MacDonald, alive but injured, lying near his wife. This early testimony established the physical layout of the crime scene, which would become critical as the case unfolded. The jury learned that Colette MacDonald had been found on the floor of the master bedroom, suffering extensive stab wounds and blunt force trauma, while the two children were found in their respective beds, also victims of extreme violence. The prosecution emphasized the distribution of blood throughout the house, including the word pig written in blood on the headboard of the bed, a detail that immediately invoked comparisons to the Mason murders that had taken place months earlier. But even in these early stages, the government began planting seeds of doubt about MacDonald's story. The living room, where MacDonald claimed a violent struggle had taken place against multiple intruders, did not show the level of disarray that one might expect from such a fight. There was no widespread destruction, no clear evidence of multiple attackers moving through the space in the way that MacDonald described. As the prosecution continued, they called investigators from the Army's CID division, including William Ivory and Robert Shaw. These witnesses helped the jury understand how investigators began to interpret the evidence in the days following the murders. Their testimony focused on inconsistencies between MacDonald's account and the physical evidence found inside the home. One of the key themes that emerged was the movement or lack of movement within the house. According to the prosecution, the evidence suggested a sequence of events that began in the master bedroom and moved into the children's room, rather than a chaotic attack unfolding simultaneously across multiple areas in the home. This interpretation was supported by the distribution of blood types throughout the house, which allowed investigators to trace where each victim's blood had been found. Because each member of the MacDonald family had a different blood type, as I mentioned in a previous episode, investigators were able to map patterns that they argued were inconsistent with MacDonald's version of events. Colette's blood type appeared in areas that suggested that she had been attacked in the master bedroom and possibly moved, while Kimberly's blood was found in locations that indicated she may have been attacked outside her own room before being returned to her bed. Which, why would an intruder take the time to return one of the children back to their bed after a home invasion attack? Why would someone tuck the child back into their bed? It just didn't make sense. The prosecution used this evidence to argue that the murders were deliberate and sequential, rather than the result of multiple intruders acting unpredictably. Medical testimony played a significant role in reinforcing this narrative. Doctors who examined the bodies described the extent and nature of the injuries, emphasizing the difference between the wounds inflicted on Colette and the kids and those sustained by MacDonald himself. Colette's injuries were described as severe and extensive, involving multiple stab wounds, puncture wounds from an ice pick, and blunt force trauma. The children's injuries were similarly brutal. In contrast, however, MacDonald's injuries, while not insignificant, were comparatively less severe. He suffered a partially collapsed lung and several cuts and bruises, but the prosecution argued that these injuries did not align with the kind of sustained, life-threatening attack that he described. This contrast in injuries became a central point in the government's case. It was not simply that MacDonald survived, but that the nature of his injuries appeared inconsistent with the level of violence inflicted on the other, more vulnerable victims. As the trial moved into its forensic phase, the focus shifted to physical evidence collected from the scene. Lab analysts testified about fibers, blood patterns, and the conditions of objects found in and around the house. But the centerpiece of the prosecution's case would ultimately end up being a piece of clothing.
With Plan B emergency contraception, we're in control of our future. It's backup birth control you take after unprotected sex that helps prevent pregnancy before it starts. It works by temporarily delaying ovulation, and it won't impact your future fertility. Plan B is available in all 50 U.S. states at all major retailers near you, with no ID, prescription, or age requirement needed. Together, we've got this. Follow Plan B on Insta at Plan B One Step to learn more. Use as directed.
At first, I didn't think it was real. I woke up to this blinding light, and I was transported to another place. Pluto TV! Then I heard a voice.
Come with me if you want to live.
There were thousands of movies and shows, and they were all free. The truth is ours. It's just so beautiful.
On Pluto TV, free streaming of Terminator 2, Fringe, Arrow, The 100, and The X-Files may cause excitement, loss of sleep, and sudden belief in extraterrestrials. No credit cards or alien encounters necessary. Pluto TV. Stream now, pay never.
When the government called FBI expert Paul Stombaugh to the stand, he narrowed the evidentiary focus to Jeffrey MacDonald's blue pajama top. At first glance, it might not have appeared to be the kind of evidence that could carry significant weight, but it went on to become a forensic jigsaw puzzle, 48 holes matching 21 wounds. FBI agent Paul Stombaugh and aide Shirley Green testified that the 48 puncture holes in the pajama top could be matched to the 21 thrusts in Colette's chest only if the pajama top was folded in a very specific stationary way. Stombaugh walked the jury through his analysis of the condition of the pajama top, and he testified that there were 48 clean, symmetrical puncture holes in the fabric. He testified that if the top had been punctured during a struggle, as Jeffrey MacDonald had told everybody, the top would be snagged, pulled, ripped, and that any holes caused by a sharp object would be equally chaotic. But the pajama top didn't have those qualities. Instead, the pajama top appeared to have been punctured while laying flat and stationary, which became a test of whether MacDonald's account could be physically possible. Stombaugh then showed the jury a reconstruction of the pajama top. By folding the pajama top exactly as it was found draped over Colette's body, he could thrust an ice pick through the folds just 21 times and hit every single one of those 48 holes. The implication was devastating because it appeared to suggest that the holes didn't happen during a frantic struggle with intruders. The holes happened while the pajama top was stationary, laid across Colette's chest as someone methodically stabbed her through it. The holes were perfectly symmetrical, and the blood evidence on the top consistent with being above Colette as she was stabbed. For the jury, this created a moment of quiet but significant tension. The pajama top was no longer just an article of clothing. It had become a piece of physical evidence that either supported or undermined the defendant's account. The prosecution would later return to this point with particular emphasis. In addition to the pajama top analysis, the prosecution presented a series of expert witnesses who examined the physical evidence from multiple angles. Lab analysts testified about fiber transfers and blood typing, while other experts addressed trace evidence, including hair and material analysis. Collectively, these witnesses were not offering a single conclusion, but rather reinforcing a consistent theme. When the physical evidence was examined piece by piece, it told a contained and internally consistent story. one that did not align at all with the presence of multiple intruders moving unpredictably through the home. Another important component of the government's case involved the weapons recovered outside the home. Investigators testified that a wooden club, a knife, and an ice pick had been found near the back door, and that these items were consistent with objects from inside the MacDonald house. The prosecution argued that this detail was significant because it suggested that the weapons had not been brought in by intruders, but rather taken from within the home itself. If that were true, it would undermine the idea of an external attack and support the theory that the crime had been committed by someone who was already inside. Even though the prosecution chose not to call Helena Stokely as part of their own case, they still had to deal with the intruder theory head-on. By the time this case reached trial in 1979, the idea that a group of drug-using outsiders, aka hippies, as they were often described, might have committed these murders had been part of the case for nearly a decade. It had been raised during the original investigation, explored during the military proceedings, and discussed publicly enough that the jury was almost certain to have heard about it. So the prosecution didn't ignore it. Instead, they addressed it in a quieter, more methodical way by showing the jury that it had already been investigated and that it had ultimately led nowhere. They did this primarily through the testimony of investigators, including CID agents and law enforcement personnel who had worked the case in its early stages. These witnesses explained that in the days and weeks following the murders, investigators did not fixate solely on Jeffrey MacDonald. They followed leads. They interviewed individuals who matched the descriptions that MacDonald had provided. They looked into people in the Fayetteville area who were known to associate with drugs, unconventional lifestyles, and even the kind of appearance that MacDonald described: long hair, boots, military-style clothing. Among those individuals was Helena Stokely, of course. Investigators acknowledged that she had come to their attention early on because she appeared to resemble the female intruder that MacDonald had described. They interviewed her. They attempted to determine her whereabouts on the night of the murders. They explored whether she had any connection to the MacDonald family or to the crime scene. But what those investigators ultimately conveyed to the jury was not that Helena had been definitively ruled out in some dramatic fashion. Instead, they made a more measured point, noting that nothing in their investigation produced reliable evidence tying her or anyone else to the crime scene. And that distinction mattered, because the prosecution was not trying to prove a negative. They weren't trying to stand in front of the jury and say it is impossible that intruders existed. Instead, they framed the issue in terms of evidence. After following the leads, after conducting interviews, after examining what could be verified and what could not, there simply was no credible, admissible evidence placing outsiders inside the MacDonald house on the night of the murders. Then, when the defense later, which I'll talk about in a minute, called Helena Stokely to testify, the prosecution had the opportunity to reinforce all of these points through cross-examination, and that allowed the prosecution to bring the issue full circle. After presenting the physical and forensic evidence, the prosecution also introduced Jeffrey MacDonald's own words into the trial. Portions of his April 6, 1970 interview with CID investigators were read into the record, allowing the jury to hear his account of the events long before he ever took the stand, if he chose to take the stand, that is. And this was a strategic move. It gave the prosecution the opportunity to present MacDonald's version of the attack in his own words, while also preserving those statements for later comparison. By doing so, they effectively anchored Jeffrey MacDonald's story in time, so that if he chose to testify in his own defense, the jury could evaluate not just what he said, but whether his story remained consistent. When the prosecution finally rested, the defense stepped into what I'm going to call is a very difficult position. Imagine being a juror, sitting through all this testimony. 3 victims have been slaughtered, and you've just heard weeks of evidence saying that this man is a cold-blooded killer. Being a defendant is hard, but the defense, led by Bernie Siegel, countered the prosecution's case with a single word: bungled. They didn't argue that the fibers weren't there. They argued the crime scene was a slaughterhouse of contamination. They pointed to MPs and medics, numbering more than a dozen, who trampled through the apartment before CID even arrived. A medic had stood up a fallen flower pot. Someone had sat on the sofa where the struggle allegedly occurred. Maybe they took fibers on their clothes with them. And most shockingly, someone, likely a first responder, had actually stolen Jeffrey MacDonald's wallet right off the desk while his family lay dead in the very next rooms. Siegel's message was clear. How can you trust a fiber trail when the investigators couldn't even keep the furniture in place? The defense's goal was not necessarily to prove exactly what happened, but to demonstrate that the government could not prove its version beyond a reasonable doubt. To support this approach, the defense called a wide range of witnesses, beginning with individuals connected to the early investigation and extending outward to those linked to the so-called intruder theory. Among the most anticipated witnesses was Helena Stokely, a woman who had long been associated with the description given by Jeffrey MacDonald. Stokely was known in the Fayetteville area for her drug use and unconventional lifestyle, and at various points over the years, she had made these weird statements that some interpreted as suggestive of her involvement in the MacDonald family massacre. She was, in many ways, the defense's most important witness because she represented the very real possibility that MacDonald's story might be rooted in truth. Helena Stokely arrived in court wearing black, looking like a tragic figure broken by years of drug abuse. But on the stand, the confession that the defense hoped for evaporated. To every critical question about the night of February 7th, Stokely gave the same hollow answer. I don't remember. She admitted that she owned a blonde wig and had a floppy hat. She acknowledged that during that period of her life, she had been heavily using drugs, including substances that affected her memory. At some point, she told others that she remembered seeing a broken rocking horse in the kid's room, which was a detail the defense claimed was insider knowledge. But the prosecution countered by showing that the broken rocking horse appeared in a newspaper photo the day after the murders. In the end, Helena's testimony created a significant problem for the defense. Instead of providing corroboration, Stokely introduced more uncertainty. The one person who could have grounded the intruder theory in a concrete, identifiable reality was unable to do so. Recognizing that limitation, the defense attempted to bolster the intruder theory through additional witnesses. They called individuals who had interacted with Stokely in the days and weeks following the murders, including the people who testified about statements she had allegedly made, suggesting knowledge of the crime. Witnesses such as William Posey and others described her behavior as unusual, her statements as ambiguous, and her demeanor as troubled. However, these accounts were indirect. They were based on recollections of conversations rather than firsthand observations of the crime itself. Many of the statements attributed to Stokely were inconsistent or lacked specificity, and the prosecution was quick to challenge their reliability through cross-examination. The defense also called other individuals connected to the alleged intruder group, including people who were part of the Fayetteville drug scene at the time. These witnesses were intended to show that individuals matching MacDonald's description did exist and that they operated within a loose network of criminal associates. But again, the testimony tended to establish possibility rather than proof. It suggested that people like those MacDonald described were present in the area, but it did not place them inside of the MacDonald home on the night of the murders. In addition to pursuing the intruder theory, the defense continued to challenge the prosecution's forensic evidence. Through cross-examination and their own witnesses, they questioned the interpretation of blood patterns, the conclusions drawn from fiber analysis, and the assumptions underlying the government's reconstruction of the crime. They emphasized that forensic science in 1970 was limited, that contamination of the crime scene could not be ruled out, and that many of the government's conclusions depended on interpretation rather than scientific certainty. The defense also presented character witnesses and individuals who knew MacDonald personally, including members of his family. These witnesses described him as a devoted husband, a caring father, and a disciplined military officer. They spoke about his background, his demeanor, and his relationships, painting a picture of a man who did not fit the profile of someone capable of committing such a heinous crime. While this testimony did not directly address the physical evidence, it was intended to influence how the jury perceived MacDonald himself. They were looking at his credibility, his character, and his capacity for violence. All of this built towards the most critical moment of the defense's case, and that was when Jeffrey MacDonald himself took the stand. When MacDonald testified, he did so not just as a defendant, but as the only surviving adult from that night. Over the course of his testimony, he walked the jury through his account in detail. He described falling asleep on the couch, being awakened by his wife's screams, and encountering intruders in the living room. He recounted the struggle he claimed to have had with multiple attackers, the sensation of being struck and stabbed, and the moment he lost consciousness. He then described regaining awareness, moving through the house, and discovering the bodies of his loving wife and children. He spoke about attempting to help them, about calling for assistance, and about collapsing from his injuries. Throughout his testimony, he presented himself as a victim, someone who had endured the same traumatic event as the rest of his family, but he had survived. MacDonald also spoke about his wife and daughters in deeply personal terms. He described Colette as intelligent, warm, and devoted, and he spoke about his children with affection and emotion. This portion of his testimony was designed to humanize him, to remind the jury of what he had lost, and to frame him not as a perpetrator, but as someone who had suffered a profound tragedy. But by choosing to testify, MacDonald exposed himself to cross-examination, and the prosecution used this opportunity to challenge him directly. They questioned him about every inconsistency between his testimony and his earlier statements, including those given during his April 6 interview. They pressed him on the physical evidence, the pajama top, the blood patterns, the condition of the living room, and asked him to reconcile his account with the forensic findings that had been presented to the jury while he sat there. They also returned to the central issue that had run throughout the trial, the plausibility of his story. They asked him to explain how multiple intruders could have entered and exited the home without leaving any clear physical evidence, how such a violent struggle could have occurred without significant disruption to the living room area, and why his injuries were so limited in comparison to those suffered by his family. In that moment, the defense case reached its most vulnerable point, because while the defense had spent days introducing alternative possibilities and challenging the government's conclusions, MacDonald himself now had to account for the totality of the evidence. And the jury, having already heard weeks of testimony, was left to decide whether his explanation aligned with what they had seen and heard.
Girl, winter is so last season. And now spring's got you looking at pictures of tank tops with hungry eyes. Your algorithm is feeding you cutoffs. You're thirsty for the sun on your shoulders. That perfect hang on the patio sundress. Those sandals you can wear all day and all night. And you've had enough of shopping from your couch. Done hoping it looks anything like the picture when you tear open that envelope? It's time for a little in-person spring treat. It's time for a trip to Ross. Work your magic.
1, 2, 1, 2, 3, 4. Give me a break, give me a break. Break me off a piece of that Kit Kat bar. Give me a break, give me a break. Break me off a piece of that Kit Kat bar. That chocolate crispy taste gonna make your day. And wherever you go, you'll hear the people say, give me a break, give me a break. Break me off a piece of that Kit Kat bar.
Have a break. Have a Kit Kat.
As the trial entered its final phase, the atmosphere inside the courtroom shifted in a way that is difficult to fully capture unless you've experienced it. For weeks, the jury had listened to testimony from investigators, medical examiners, forensic analysts, and witnesses, all connected to nearly every aspect of the case. They had been presented with gruesome photographs, diagrams, lab results, and transcripts. They had heard competing explanations for what had occurred inside that house. But now, for the first time, both sides stepped back from the details and began to assemble those tiny pieces of the puzzle into complete narratives for the jury. There would be no new evidence, no additional testimony. What remained was interpretation, persuasion, and the weight of everything the jury had already heard. When Assistant U.S. Attorney James Blackburn delivered the government's closing argument, he told the jurors that this case was not about one dramatic piece of evidence, but about the overall picture created by the physical evidence inside the MacDonald home. There was no confession and no eyewitnesses, but Blackburn argued that the crime scene itself contradicted Jeffrey MacDonald's story of a chaotic attack by multiple intruders. He pointed to the blood evidence, emphasizing that each member of the MacDonald family had a different blood type, allowing investigators to trace where blood had moved throughout the house. According to the prosecution, those patterns suggested the attacks were controlled and sequential, not random or chaotic. Blackburn also focused heavily on the blue pajama top. Jurors had heard testimony that the puncture holes in the fabric were clean and consistent, lacking the stretching expected if the garment had been worn during a violent struggle. Blackburn argued that if MacDonald had truly used the pajama top as a shield during an ice pick-wielding attack, there should have been corresponding wounds to his hands and arms, but those injuries did not exist. He then addressed the intruder theory directly, reminding jurors that investigators had already looked into possible suspects, including Helena Stokely, but found no reliable evidence placing outsiders inside the house. There were no unidentified fingerprints, no signs of forced entry, and no physical evidence supporting the presence of intruders. Finally, Blackburn posed what became the prosecution's defining question. If the attackers were violent enough to brutally murder a pregnant woman and 2 children, why would they leave the presumably strongest adult witness still alive? According to the government, the answer was simple. Jeffrey MacDonald survived because he was not a victim at all. When defense attorneys Wade Smith and Ben Siegel delivered their closing arguments, they focused on one central idea: doubt. While the prosecution argued that the evidence formed a clear and logical picture, the defense reminded jurors that the investigation itself had been deeply flawed from the very beginning. They emphasized that the crime scene had not been properly secured. With multiple people moving through the house in the critical early hours, they were creating the possibility that evidence had been contaminated. It had even been moved or misinterpreted. They argued that much of the government's case depended on interpretation rather than certainty. The prosecution, they said, had taken complicated forensic evidence and presented it as though there could only be one explanation, when in reality, other explanations, reasonable explanations, were still possible. They reminded the jury that the defense was not required to prove exactly who committed the murders or fully establish the intruder theory at all. Their burden was not to solve the case. The burden belonged entirely to the government, and they had not proven their case. Turning to the issue of intruders, Smith, one of the defense attorneys, pointed again to testimony involving Helena Stokely and others in the Fayetteville drug scene who resembled the description given by MacDonald. While acknowledging Helena's inconsistencies and heavy drug use, Smith argued that her existence alone created unanswered questions the government had never fully resolved. According to the defense, investigators focused too quickly on Jeffrey MacDonald while failing to thoroughly pursue alternative suspects. Smith then brought the argument back to the legal standard of reasonable doubt. He told jurors that suspicion, even strong suspicion, was not enough to convict a man of murdering his entire family. The government, he argued, had built a theory, but a theory was not proof beyond a reasonable doubt. Finally, the defense urged the jury to think about the man they had watched testify during the trial, a former Army doctor and a husband who had consistently maintained the same core account of events for nearly a decade. The jury was asked to consider whether the prosecution had truly eliminated every reasonable doubt, or whether the prosecution was simply asking the jury to accept interpretation as certainty. When the defense finished, the courtroom fell silent. The fate of Jeffrey MacDonald was now in the hands of the jury. As the closing arguments came to an end, the courtroom entered a phase that often feels quieter on the surface, but is in reality the most consequential moment of any trial. The attorneys had said everything they could. The evidence had been presented for weeks, challenged and reframed from every possible angle. Now it was up to the jury. Judge Franklin Dupree Jr. delivered the final instructions, carefully outlining the law the jurors were required to follow. He explained the charges, the elements the government was required to prove, and most importantly, the standard of proof. Proof beyond a reasonable doubt. He reminded the jury that speculation was not enough, that sympathy could not guide their decision, and that their verdict must be based solely on the evidence presented in the courtroom. With those instructions, the jury was formally charged and then escorted out of the courtroom to begin deliberations. At that moment, the energy inside the courtroom shifted. The attorneys gathered their papers, the spectators began to whisper, and Jeffrey MacDonald, who had spent weeks sitting at the defense table listening to the testimony about his life and the deaths of his family, was simply left to wait. I can't imagine how agonizing that is for anybody, the perpetrator, the family members of the victims, everybody. Outside the courtroom, the atmosphere was anything but quiet, as you can imagine. The trial had drawn significant national attention, fueled in part by the shocking nature of the crime and the unresolved questions that had lingered for nearly a decade. Reporters from major outlets had been present throughout the proceedings, and as deliberations began, they remained stationed right outside of the courtroom, waiting to provide updates for the verdict at any minute. Cameras were positioned, notebooks were open. The story, which had already captured public fascination, was now approaching its conclusion, at least in this chapter. Inside the jury room, the deliberations began. 12 individuals who only weeks earlier had been complete strangers were now tasked with evaluating a case that spanned nearly 10 years. And it was so many layers upon layers, forensic layers, conflicting interpretation layers. And let's talk about the layer of emotional testimony. They had to decide what was possible. And the most critical question that they had to examine was, did the government's case meet the high burden required for a criminal conviction?
Your team is global. Your payment should be too. Pay straight from your existing bank account or debit card. No new wallet, no complicated setup. Verify your business once, and you're set. Paying your global team shouldn't feel like a job. That's Remitly Business. Sign up at remitly.com/small business month. Remitly Incorporated is licensed as a money transmitter by the New York State Department of Financial Services and in Puerto Rico TM-143, a foreign transmittal agency in Massachusetts and a currency transmitter in Rhode Island. NMLS number 1028236.
After several hours of deliberation, the jury notified the court that they had reached a verdict. Jeffrey MacDonald stood as the jury entered the courtroom. The foreperson handed the verdict form to the clerk, and then, one by one, the verdicts were read. On the charge of second-degree murder in the death of Colette MacDonald, the jury found the defendant guilty. On the charge of second-degree murder in the death of Kimberly MacDonald, the jury found the defendant guilty. On the charge of first-degree murder in the death of Kristen MacDonald, the jury found the defendant guilty. The words hung in the air for a moment as if the weight of them needed time to settle. And after the last verdict was read, Jeffrey MacDonald just stood there. It was the moment that his legal status changed permanently. He was no longer simply a defendant accused of these crimes. He was now a convicted murderer. Some would say he was one of the first high-profile family annihilators. Following the verdict, the court moved into sentencing. Judge Franklin Dupree imposed 3 consecutive life sentences, one for each victim. And with that, the federal trial formally concluded. It's crazy how trials feel like they take forever, especially this one. It took almost a decade to get to trial, but then suddenly they feel like they're over so soon. Outside the courthouse, the verdict spread almost instantly. Reporters relayed the outcome to a national audience, framing it as the resolution of one of the most controversial and closely watched murder cases of its time. For many members of the public, the verdict provided a sense of closure. But for others, it raised new questions. Questions about the evidence, questions about the investigation, and questions about whether justice had truly been served. Because as would soon become clear, this case was far, far from over. Almost immediately after the verdict, MacDonald's defense team began filing appeals, arguing that serious legal errors had occurred during the trial. Their arguments spanned a wide range of issues, including evidentiary rulings, the handling of witnesses connected to the intruder theory, and whether MacDonald's constitutional rights had been violated during the nearly decade-long delay between the murders and the federal trial. That final issue, the delay, that would become the centerpiece of one of the most dramatic twists in this entire case. Hold your horses, y'all. Remember when I told you in part 3 that the appellate court had kicked back an appeal and told MacDonald that his issue wasn't ripe for appeal until after the trial? Yeah, well, now we have a conviction, and Jeff's team refiled that speedy trial appeal. MacDonald's attorneys argued that the government had violated Jeffrey MacDonald's Sixth Amendment right to a speedy trial. They pointed out that the murders occurred in February of 1970, that the military had originally dismissed the charges later that same year after the 32 hearing, and that MacDonald then lived openly for years before being indicted federally in 1975. According to the defense, the extraordinary length of time between the original accusation and the eventual federal trial had unfairly prejudiced MacDonald's ability to defend himself. They said witnesses' memories had faded, evidence deteriorated, potentially favorable testimony became harder to obtain. The defense argued that the delay itself undermined the fairness of the prosecution. And initially, the appellate courts rejected those arguments. They were like, no, we did not violate your rights. But even after that setback, MacDonald's defense team continued filing additional appeals and collateral challenges. And then came one of the most shocking moments in the post-conviction history of this case. In 1980, the Fourth Circuit ruled in MacDonald's favor. Yes, you heard that correctly. They ruled in MacDonald's favor on the speedy trial issue. The court concluded that the delay between the original military proceedings in 1970 and the later federal indictment had violated MacDonald's constitutional rights. And as a result, the Fourth Circuit vacated his conviction and ordered the indictment dismissed. That ruling was huge because while portions of the appeal process were still unfolding, another federal district court judge ordered MacDonald released on bail after the Fourth Circuit made their ruling. The decision to release him was extraordinary. Convicted murderers, especially those convicted of killing multiple family members, are rarely released after a conviction is overturned on appeal. Yet MacDonald walked out of prison, and for a very brief period, he returned to civilian life while his appellate litigation continued. For supporters of MacDonald, the release felt vindicating. They viewed it as evidence that the courts recognized legitimate questions surrounding the conviction. For critics and members of Colette's family, however, Jeffrey's release from prison was devastating. To them, a man convicted of brutally murdering his wife and kids was now free while appeals slowly moved through the courts. And MacDonald did not disappear quietly into anonymity during that period, as you can imagine. He lived openly in California, continued working on his legal defense, and remained deeply engaged in public discussions about his case. But don't worry, the story did not end there. The United States government appealed the Fourth Circuit's ruling all the way up to the Supreme Court, and in 1982, the United States Supreme Court reversed the appellate court's decision, holding that the Sixth Amendment speedy trial protections did not apply during the years between the military dismissal of charges and the later federal indictment. Because get this, during that period, MacDonald was not under active criminal accusation. In other words, once the Army dropped the original charges in 1970, the constitutional speedy trial clock stopped. It stopped running until federal prosecutors formally re-indicted him in 1975. That Supreme Court ruling effectively reinstated MacDonald's conviction. As a result, MacDonald was ordered back into custody to continue serving his life sentences. He surrendered and returned to federal prison after having briefly lived free following the appellate court's decision. But if you think the appeals stopped there, they did not. Over the following decades, MacDonald's legal team continued filing motions and petitions. They were challenging the conviction on multiple grounds. One major focus involved claims of newly discovered evidence, particularly evidence connected to Helena Stokely and the alleged intruder theory. Defense attorneys argued that prosecutors had improperly withheld favorable evidence and that certain witnesses connected to Stokely should have been allowed to testify more extensively during the trial. They also pursued DNA testing on various hairs, fibers, and trace evidence collected from the crime scene. They were hoping modern forensic analysis would support the intruder theory or undermine confidence in the conviction. The courts repeatedly reviewed those claims over the years, and several hearings were held examining whether new forensic testing or witness statements justified a new trial. At various points, MacDonald's supporters believed that they were close to obtaining relief. Yet time and again, courts ultimately concluded that the new evidence either lacked sufficient reliability or would not likely have changed the jury's verdict. By the 2000s and even into the 2010s, the MacDonald case remained active in federal courtrooms. And in 2006, there was a break in the case. After MacDonald successfully argued for DNA testing, they did the testing, and the DNA test revealed that 3 hairs found at the crime scene didn't belong to the MacDonalds or the alleged known perpetrators. MacDonald argued that this was the smoking gun to his innocence, because maybe it wasn't those intruders, maybe it was some other intruders. But listen, y'all, the same test delivered a blow to MacDonald's defense. You see, one of the hairs found in Colette's bloodied hand, which the defense had originally claimed belonged to an intruder, after this 2006 DNA test, it was revealed that that hair with blood on it was a 100% match to Jeffrey MacDonald. And the question was, why was that bloodied hair there? Was Jeff reviving Colette as he claimed? Or was it the final trace of a struggle? Ultimately, the government asserted that these genetic tests provide no proof of innocence and instead support the original 1979 conviction. In 2018, the Fourth Circuit Court of Appeals again rejected efforts to overturn the conviction, concluding that the lower courts had not erred in denying MacDonald a new trial. Even decades after the murders, the legal system was still revisiting the same haunting questions that first emerged in 544 Castle Drive in 1970. And that perhaps more than anything else, explains why the Jeffrey MacDonald case continues to fascinate people to this day. Because unlike many murder cases that conclude with a conviction and quietly fade into history, this one never truly settled. The verdict ended the trial, but it did not end the debate. For decades afterward, courts, journalists, authors, and armchair investigators continued and continue asking the same question that the jury faced in 1979. Did the evidence reveal the truth, or was there still something missing? Next time, in part 5, I will wrap up my discussion on Jeffrey MacDonald. I will discuss the 2012 Wilderness of Error analysis. I will be watching the docuseries and briefing that to all of you, so stay tuned for part 5. Thank you so much, True Crime Army, for listening in. I really appreciate all of you who have reached out to me to tell me how happy you are that I'm finally covering this case. And listen, if you have the opportunity to leave me a 5-star rating, to rate the show, or to just share it with a friend, please do so. This case is really devastating, and it is really one of the most infamous military murder cases that I have ever covered. I do realize that I have been putting it off for a very long time, but here we are. My sources for this miniseries include various appellate court opinions, as well as case documents found on 2 websites. One is MacDonaldFacts.com, and the other is CrimeArchives.net. I also relied on excerpts from the book Fatal Vision and articles on Oxygen, the National Association of Criminal Defense Attorneys, Columbia Journalism, the Miami Herald, ABC News, and People Magazine. Military Murder is a Mama Margot production. The music was created by Ty-Ops. Until next time, remember, you never really know what someone is capable of, so remain vigilant always. You have a fabulous week, and I'll keep digging to bring you the conclusion of this miniseries next time.
Mama's working on her podcast. I don't want to.
Ryan Reynolds here from Mint Mobile with a message for everyone paying big wireless way too much. Please, for the love of everything good in this world, stop. With Mint, you can get premium wireless for just $15 a month. Of course, if you enjoy overpaying, no judgments, but that's weird. Okay, one judgment. Anyway, give it a try at mintmobile.com/switch.
Upfront payment of $45 for 3-month plan, equivalent to $15 per month required. Intro rate first 3 months only, then full price plan options available. Taxes and fees extra. See full terms at mintmobile.com.